The U.S. is one of the easiest jurisdictions in the world in which to do business and continues to be the world's top destination for FDI. Barriers to market entry are generally low outside of a few highly regulated industries. Establishing a branch or a business entity is quick and easy. Labor and employment laws are much more employer-friendly than in most other developed economies, and the legal system is well-developed and transparent. While U.S. persons can generally acquire, invest in, or establish a business without partnering with a local company or individual, federal law provides the President of the United States with broad power to block or restrict certain investments that adversely impact national security. In the absence of an employment contract or collective bargaining agreement, and it's worth noting that both of these are relatively rare in the U.S. Employment contracts are generally not put in place except for the most highly compensated employees, and collective bargaining agreements are rare outside of a few industries. Employees in the U.S. are employed at will and are terminable at the option of either party at any time. Various state laws and state decisions have eroded this at-will doctrine to some extent, but the doctrine is a fundamental principle of labor laws in the United States. Although a non-U.S. company establishing operations in the U.S. cannot completely eliminate the risk of litigation, there are certain steps that it can take to limit the exposure of upstream subsidiaries and the parent corporation. First, it can form a U.S. entity to achieve limited liability. That U.S. entity should have different officers and directors than the parent company. They can overlap, but they shouldn't be identical. And great care should be taken to maintain the financial and managerial separateness of the entities, and to make sure that the U.S. subsidiary is adequately capitalized to fund its anticipated obligations and expected expenses.